Hello, everyone. Hey, welcome to this terrific, tremendous Tuesday. We're going to talk about some more VA disability. Hey, for those who don't know, VA accredited attorney Matthew Lang here. Years of experience in the VA, veteran myself. Been now outside the VA, still doing more VA disability representation here for the last few years. Let's get down to it. We are here, as always, to talk about something inside the VA when it comes to VA disability. Typically, the rule, a law, a guidance that is put out in order to help make the process smoother between veterans and VA there when it comes to disability claims. As you probably already gleaned before you're coming in the video, we're going to talk about this thing called mere speculation. What is it? What are we talking about? Well, here's what we're going to do. We're going to talk about this mere speculation piece. This is just a portion of the medical opinion and medical examination side. Some of the rules that involve there. I'm going to use the speculation piece of it all to talk about this, and in the future, we're definitely going to do more videos. I believe we've already done a few that talks about the duty to assist, and that talks about adequacies of opinions and some other issues that kind of land in here too. And we're going to keep doing it, is my point. But for today, we're going to talk about the speculation piece. Why? Because I've seen it hit my desk a few times now, and it's hit my desk enough to create concern, and I want to make sure that the rule is understood better and that claims aren't just being denied when they're not supposed to be, because that's what's happening. VA, when you do that, understand you're altering somebody else's life, a veteran's life, and you put them on a hamster wheel. You may move it out of one pot of a backlog and into another pot, but it's still there. It's still got the veteran running unnecessarily on a hamster wheel there and delaying the claim. So let's see if we can stop doing that. And let's talk about the speculation. Let's get to it. I'm going to talk about a section of the manual, VA's M21.1, that really summarizes the court cases here. They do have 3 of them listed here in their M21 on this section. That's the Davies v. Nicholson, Jones v. Shinseki, and Sharp v. Shulkin. All good cases. They all have a different portion or different fact pattern when it comes to disability law. Davies v. Nicholson talks about the DIC, a survivor benefit, and an issue with the medical opinion there being speculative. Jones v. Shinseki here talks more about service connection, as I recall. And then Sharp v. Shulkin is more of the increases, typically kind of talking about those flare-ups and stuff. So that's in general what those are. But they all play a role. I'm going to rely on Jones because the Jones case here answered the question, I think, in the most detail. Davies didn't have really the opportunity in the fact pattern to do so. They did answer a little bit, so the Jones case does refer back to the Davies case, and Sharp refers to Jones. So with Jones being the big one, we're going to talk about that one. I'm going to give you this manual reference here. Remember, this is all public out there. You can find this, veterans, on the VA's knowledge portal or website there. I'll try to remember to include the link in my description. If I don't, throw me a comment and say, hey, Dr. Lang, Attorney Lang, you forgot again. I'll definitely throw it in there. Sometimes I get busy when I'm editing stuff and reviewing things, and yeah. You know how it is, right? Just forget. Hey, so with that though, these court cases that are cited inside the M21 here in this reference, so you can actually pull up the VA's summary of them. You can also find the citation form. Veterans, if you want to be as well, they're in there for you. You can find the citations and you can Google those and usually pull up the whole case. And within a certain year, set of years, I don't recall what it is off the top of my head. I think it's after 95, maybe. Don't quote me on that one. You can find pretty much all these court cases, could be after the year 2000, actually. Anyways, you can find a chunk of them within a certain time frame that are on the CAVX website itself, and you can actually pull those and read these court cases. Anyhow, let's do this. I'm going to read this manual reference citation a little funky, just in a way that you can jot it down a little easier and know where I'm at. So if you want to review this later on, you can. M21-1, Roman numeral 4, period, lowercase I, period 3, period capital A, period 1, period Q. So if you need to rerun that back, do that for me. For yourself and jot that down. Take a peek at this. Again, it's a really short section. It's a one-pager. Just really sums up this court cases. But here's what it says. Starts off with these fine words that I think are very important and really highlight the importance of this section. It says, pay careful attention. Pay careful attention. Pay careful attention. I just said it 3 times, so I hear that helps when in the remembering process. It says pay careful attention to any conclusion by the examiner that an opinion could not be provided without resorting to mere speculation or any similar language to that effect. So it starts out with paying careful attention. This is very crucial. This is very important. I feel that this is what the higher areas of the VA are wanting those who make decisions to understand, that you really have to pay attention to this. You may not be able to accept this mere speculation opinion as a reason to deny. You really need to pay close attention to it. There's a lot that's involved. I think there's really a lot involved in every exam when it comes down to the criteria of adequacy. But when we stick with the speculation piece here, it does go on to say VA may only accept a medical examiner's conclusion that an opinion would be speculative if the examiner has explained the basis for such an opinion, identified what facts cannot be determined, and demonstrate consideration of all procurable and relevant information to include medical treatment records and or lay testimony. That's the big part for what you're looking for, VA, from your manual here. That's really just cited, really a watered down explanation of what's in the court cases here. You really got to pay attention to that rationale as provided with that opinion. Is it truly explained? Is it providing enough information? And we're going to really talk about that from the court case here. The other part that's on here is or the basis for the opinion is otherwise apparent in VA's review of the evidence. Now, VA, I caution you on this one because it's not written wrong here. I mean, it's not a wrong statement in my professional opinion here by any means, but I'm concerned that that statement may give you the idea that you can add your own medical opinion to it when the VA examination says mere speculation. That is not the case. There's a whole other rule that says don't do that, not allowed. So remember, that's not what that line there says. And we're going to talk a little bit about it from the court case and ultimately what that means. But please keep in mind, there's other rules that say you can't just give your own medical opinion outside the examiner there. The reference does further go on to say the medical opinion may be insufficient for rating purposes if an examiner's conclusion is not adequately justified. And we're really going to talk about what adequately justified is, because the courts really go into explanation with that here in the Jones case, or implies a general lack of knowledge, or in a aversion to opining on matters beyond direct observation. So keep in mind, this is going to really highlight the issues of if the examiner themselves lack the knowledge, and that's why mere speculation, that makes it insufficient. It's not adequate. We're going to talk about that through the court case as well. And then, or if they state that they can't provide without mere speculation because of matters beyond direct observation. Remember, medical opinion covers not only direct observations, but what is plausible, what is subjective, and everything in between. Supposed to, anyways. Excuse me. The reference does say in such instances, seek clarification of the conclusion. So VA here, what I really want you to take, I would prefer you to take, and I'm going to beg you to. This is my personal request now at this point. Take from your guidance here that you've got to pay careful attention. This is very important section, just like all of them, but you've got to pay careful attention. Just the words mere speculation alone is not a negative opinion necessarily. There's definitely criteria that needs to be met first. Now, this waters it down quite a bit in the summary of it all. So let's go to the court case and let's see what the courts had to say in Jones. Like I said, this one's did the heavier lifting, so we're only going to talk about that one. But you will find in the summary that the VA has for Sharp, pretty much a summary of Jones as well. So also a good section to look as well. So the court ultimately came down to the point in Jones that they really decided they've got to answer this question about mere speculation. They've got to answer it with more clarity than what they may have in Davies, just because Davies, my opinion, professional opinion says that Davies just didn't have that opportunity to fully go into it, and it seemed to be kind of isolated. But here, Jones says, no, we really got to figure this out. Now, the Jones case does say that an examiner's conclusion that a diagnosis or etiology opinion is not possible without resort to speculation is a medical conclusion just as much as a firm diagnosis or a conclusive opinion. So this is where that careful attention comes. We're not saying that the opinion that says it can't provide an opinion without mere speculation is not a valid opinion in of itself. It can be, and that may be fine. However, as the court continues on, however, a bald statement that it would be speculative for the examiner to render an opinion as to etiology or diagnosis is fraught with ambiguity. That's going to become a problem now. So if that speculation opinion is really ambiguous or lacks a lot of this other criteria for adequacy that we're going to go into, I think what the court here is trying to say is, yeah, now it doesn't stand on its own anymore, and now it's not adequate, and it does need to be readdressed. It gives an example down here. I'll just kind of read this through here. It does say, for example, it is not clear whether the examiner lacks the expertise to render such an opinion, or whether some additional testing or information is needed and possibly available that would permit such an opinion, either of which would render the opinion inadequate for resolving the claim. And that's where I went back to Davies, because Davies, he said, was really about a piece of medical evidence that was missing that really potentially led to that speculation opinion. And if that's the case, well, then we can still fix this potentially. So let's go get that record and have a new opinion drawn up, have those records reviewed, and let's make it happen. That's if it's possible to obtain those records. Does go on to saying thus before the board in this case, but this applies to VA wide. Just because it says board VA doesn't let you off the hook. This implies you as well. Can rely on the examiner's conclusion that an etiology opinion would be speculative. The examiner must explain the basis for such an opinion, or the basis must otherwise be apparent in the board's review of the evidence. They cited to the Steffel v. Nicholson case here. VA, I would highlight this case for sure, as well as Jones, because this is a 2007 case that is very good law still, and definitely talks about some of those requirements that are needed when it comes to a medical opinion. They do mention that they do kind of cite it. It says a medical opinion must support its conclusion with an analysis that the board can consider and weigh against contrary opinions. So really what we're looking at in here as well is not only does it have to be an adequate opinion, but if it has to be to the point where the decision can explain the reason for such opinion. So I think that kind of goes back into our little or piece back here in the manual reference. The basis for the opinion is otherwise apparent to the VA's review. So can you actually clearly state that in the decision that it's apparent in the review? So I think one note I would put there is what I see a lot of times is, unfortunately, VA, you do just a copy and paste of the VA opinion or rationale. That's not an explanation. That's a copy and paste. So I think we have another error now here when we come to reasons and bases and due process and all that. So we won't get into that part here, but kind of understand that that's, I think, it was what's being talked about here is another error that can occur. It's got to be really written in a way that VA, you can actually describe it in the decision and make sense of it. Does say furthermore here, must ensure that any medical opinion, including one that states no conclusion can be reached without resorting to speculation, is based on sufficient facts or data. Does say, see, then I'll apologize on the name here because I think I've messed this one up when I say it, but see the Nieves Rodriguez v. Peak case. Again, VA, this is another important one I'd like to highlight for your review, because it also is one that talks a lot about adequacies of exams and what's required. So the case goes on to say, therefore, it must be clear from either the examiner's statements or the board's decision. So we talked about that up here with, just a minute ago, and really it's being reinforced here. And well, this case here is 2009 now, so even 2 years later, it was being reinforced. And then here we are in the Jones's case in 2010, 1 year after that, talking about it again. So must be clear from either the examiner's statements or the board's decision. So got to be explained in detail. It's got to be clear, a clear explanation. That, again, the examiner has indeed considered all procurable and assembled data by obtaining all tests and records that might reasonably eliminate the medical analysis. And again, send you back to Davies. So the idea there is maybe there's a test that can be done, another medical test that can be done, so we don't have to have a speculative opinion or can't resort without mere speculation. Maybe we can get a clear opinion. Those tests should be ran. The court says, hey, well, if you can get that test, why don't we get it? Get that test and then tell me what you think. I think is what the court is really getting at there. Kind of the same thing. If there's a missing piece of evidence there that can be obtained, a record that would be relevant in order to potentially lead to a positive or a negative, just a clear opinion in itself, then why not? Do we not have a duty to go get that? And let's go get it and let's try that opinion again. So these are just gaps that say, hey, this is insufficient, it's inadequate. It's because it opens up the door to other duties to assist, for example, that are required. We can't just make opinions just to be saying we don't want to go get those records or saying we don't want to go get those tests done. Assist the veterans. It does say here when the record leaves this issue in doubt, it is the board's duty to remand for further development. So again, VA, that's telling you you've got to defer that back. You got to send it back when that speculation leaves as a opinion leaves the record in doubt. Then it's got to go back. Got to send it back. Court goes on here to say the examiner may also have an obligation to conduct research in the medical literature depending on the evidence in the record at the time of examination. See Wallen v. West. Yeah, that's a 1998 case. Ooh, where did we go back in time? That's another issue here. So what I hope you're seeing here in this discussion is the multiple steps and things that have to be looked for. We can't just go, oh, speculation, it's not positive, deny. We got to go, why? Why is it speculation? Can we get another opinion? Is there other evidence that would help that opinion that should have been gathered? Is this clearly on is facts based on the sufficient facts and data? Is this a biased opinion? Is this now something that the examiner can go research and maybe provide a different opinion that's not speculative? Is this really in their wheelhouse? Is that causing us another problem? Let's say the VA, let's see what veterans, let's see what the court has to say if it's just really not in the examiner's wheelhouse. We already got the research piece here. It goes on and says, the phrase without resort to speculation should reflect the limitations of knowledge in the medical community at large and not those of a particular examiner. So I think this is a huge piece too. Usually when I see a speculative opinion, or opinion saying I can't provide an opinion without resorting to mere speculation, it's because the individual provider themselves or examiner themselves can't provide it. It's not because the medical community at large can't provide it. So at that point, the court would say it's inadequate, needs to go back. And you've kind of seen that again in that manual reference right there. Remember when it says implies a general lack of knowledge? Yeah, the examiner has a general lack of knowledge, and this could be possible. There's a lot to keep track out there. Even being an attorney, I don't know every law out there. I specialize in certain areas. So examiners will do the same thing. They may not have that knowledge. Maybe they didn't do the research. If they didn't do the research and they're just based upon the lack of knowledge, well, then it should go back because the medical community at large can still answer it. And maybe another examiner can answer it and likely can. So we got to go get that. I'm going to give this final piece here without going through the whole case. It's a very lengthy case, but this should hammer out most of the requirements for adequacy and make that make sense, hopefully with the speculation piece. It does say here the examiner should clearly identify precisely what facts cannot be determined. For example, it shouldn't be clear in the examiner's remarks whether it cannot be determined from current medical knowledge that a specific in-service injury or disease can possibly cause the claim condition, or the actual cause cannot be selected from multiple potential causes. So I think this is huge too, because what I find fascinating here is I have seen just the statements and the conclusions from examiners, even in non-speculative opinions. And I'm going to go off the track just a touch, but not completely because it's still the adequacy issue. But I've seen them state that there is no supporting medical literature to make a connection between two, or that there's a relationship between say secondary conditions. I'm intrigued by that because we find that there is when that's stated. So I think at this point, it should be clear that the examiner's remarks, whether it can not be determined from current medical knowledge, I think maybe we need to go looking for more than just that conclusionary statement. I think in a lot of cases that we work with here, and VA should also be familiar by now, maybe not, with those connections that are out there. So when you see that, you can kind of call that BS on that provider and go, that's your lack of your own knowledge. Therefore, it's got to go back. So I find that interesting. We do see also I've also seen in the rationales where examiners try to say, well, there's all these other possible potential etiologies for the condition, and that's why they're denying it. But they can't just state there's other possibilities. They gotta go, why? Why in this evidence and these facts? Why? Why is it not possible that service caused it? Sure, there's other etiologies that could also be related, but what's the facts in this case? What would the medical community at large say about this case? So those are things to kind of look at there. So anyhow, everybody, I'm hoping you got something out of this. I went in a little more detail than I normally do in a lot of these videos. I really want to hammer this one out because, like I said, I'm seeing it creep up. I've used to see it a couple times in the VA when I worked there. It was definitely something that I'm going to go on a limb here and for you and probably say something that's not very well liked. But it was something that I felt we were not trained on very well. It was a habit to see it and just deny the claim as if because it didn't mark the positive box. But VA has their own guidelines that says that don't do that. It's there. That's what that whole page really says. It says pay close attention, careful attention. Make sure that speculative opinion has everything it's supposed to have. Really make sure all opinions do. But if they say resort to mere speculation, I think the biggest takeaway is, can the question be answered by another examiner? Can it be answered by another piece of evidence? Can it still be answered? I think is your question that you got to be asked. Can it still be answered? Go through the court cases. Go through these ones that are cited here. Go through the Jones case. Go through the Sharp case. Go through the Davis case. Check them all out. Good information. Definitely some lengthy reads on some of them, but good information. So there you go. Ladies and gentlemen, veterans, dedicated VA employees, and everybody watching, thank you so much. Please feel free to leave any helpful comments. Do be careful what you put in there. Don't put any personal information out there on your own case. Try to protect that information. If you do have any questions, veterans, with your cases, you want potential representation, you want to chat about those cases, again, veteranlane.com. My calendar is there. I'm finding it is filling up a lot quicker than usual. I have reasons to believe why, but I'm not here to point any fingers. So if you want in, I would probably check sooner than later. But always keep in mind, you also have VSOs out there, you got other agents, you got other great attorneys. So if you can't reach me, there's always help around the corner. But I wouldn't be mad if you did check me out first. All right. I'll leave you with that. Have a wonderful day. Thank you, everybody. I'll see you next Tuesday.